Good morning, everybody. We had an order come in from Judge Liman last night, so I'm only just getting to it now. This is regarding the New York Times. They filed a motion for a declaratory judgment. They have since filed a lawsuit in the Supreme Court, the New York Supreme Court, against Wayfarer, seeking their attorney's costs and fees and etc. So that is why they are seeking this declaratory judgment from Judge Liman. The last time on the Lively Wayfarer docket, Judge Liman issued an order. So I'm just going to quickly make that bigger and then read it. Okay. Defendant, the New York Times Company, moves pursuant to Federal Rules of Civil Procedure 54B for entry of final judgment in its favor against consolidated plaintiffs Wayfarer Studios, Justin Baldoni, Jamie Heath, Ensworth Moody, Melissa Nathan, Jennifer Abel, Steve Sarowitz, the Wayfarer parties. The Wayfarer parties have not filed an opposition. Federal Rule of Civil Procedure 54B permits the court to enter partial final judgment when it has made a final decision with respect to one or more, but not all claims in a case. The entry of final judgment in that circumstance starts the time running for an appeal. The rule provides in pertinent part, when an action presents more than one claim for relief, whether as a claim, counterclaim, cross-claim, or third-party claim, or when multiple parties are involved, the court may direct entry of a final judgment as to one or more but fewer than all claims or parties only if the court expressly determines that there is no just reason for delay. On June 9, 2025, the court granted defendants' motion to dismiss and dismissed the complaint in its entirety. Although the court granted the Wayfarer parties and not the Times leave to file an amended complaint by June 23, 2023, the Wayfarer parties did not do so. Thus, it appears, with one possible exception detailed below, that the decision became final as of June 23rd as to all parties. The Times motion is predicated on the mistaken notion that the court's order dismissing the complaint in this case will not become final until after a final decision is rendered in the Lively action. The court consolidated this case with the Lively action pursuant to Federal Rule of Civil Procedure 42A2 by order of January 30th, 2025. But the effect of that order was not to make the time to appeal a final judgment in this case run from a final judgment in both cases. Rule 42 does not have such an effect. As the Supreme Court has clarified, even when cases are consolidated, constituent cases retain their separate identities, at least to the extent that a final decision in one is immediately appealable by the losing party. The court has not entered a separate document reflecting the judgment in this case, nor have 150 days run from the date of the court's June 9th, 2025 order. Accordingly, the parties are directed to show cause by no later than October 24, 2025, why final judgment should not be entered and why the Times motion should not be dismissed as moot. In doing so, the parties should address whether any pending motions for fees and costs, including those brought under anti-SLAPP statutes, mean that the decision in this case is not, in fact, final as to all parties. So the parties here have to file by October 24th their reasons. why the Times motion should not be dismissed as moot. Okay, and they also need to address whether any pending motions for fees and costs, including those brought under anti-SLAPP statutes, mean that the decision in this case is not, in fact, final as to all parties. So this is not just the New York Times, this is not just Wayfarer, this is Lively, and this is Sloan. We haven't seen any requests for fees and costs from Ryan Reynolds. So yeah, that would be all parties. That'll be interesting. October 24th is going to be busy. Okay, that's it for me for now. I'll be back for the next one.